We're joined now by the Group CEO of NUMSA Investment Company and Executive Chairman of 360 GSG, Khandani Msibi. A very good evening to you, Mr. Msibi, and thank you so much for speaking to us. We heard the presidential spokesperson outline some of the imperatives of the amendment bill. We know that the DA and Solidarity are already looking at court action to overturn it. Are there legal challenges to this amendment bill?
Good evening, SABC, and thank you for having me, and good evening to the viewers and listeners. Look, I mean, the South Africa has become very common for political parties to use the courts in order to force a specific legislative direction, and it remains to be seen if the courts will actually agree with them. But I think there's pragmatic aspects of this bill as it becomes law that one needs to look at in terms of what is the intention, what prompted it, what is the intention, and what are the possible unintended consequences. Because I mean, with all legislation, there's always the conflict between the intentions and the unintended consequences of the legislation.
Let's look at the intentions then with equal pay for equal work framework. The issue of secrecy has been raised before. Does the bill tackle that? In some way it does, but there are limitations to it, because I mean there's things that have to do with the privacy. There's things that have to do with the ownership of companies, where someone starts a company and will not want the information to be made public. And I think the state is intending to use its procurement pests in order to force companies to comply, but also to enforce this on companies that don't necessarily rely on the state for their business. And this is the point that I was going to get to. Among the penalties that the state can take for non-compliance, would that be then, for instance, disqualification from public sector tenders, beyond fines and litigation?
I think the public sector tenders is the state's major tool of a compliance. I worry about it because I mean the bill itself, it also creates loopholes for SMMEs. It says SMMEs that are employing less than 50 people are exempted, and also it doesn't place any turnover limitation. In other words, a business can employ 49 people and still do a billion rands with the state and not be bound to comply with this employment equity requirements. So it's kind of a tool that could actually be rendered blunt, because what prompted the state in the first place to come up with this bill is because every year in January, when they release the employment equity statistics, the Minister of Employment and Labor will always complain about the lack of progress. And when they try to come up with legislation that should actually enforce the progress, they also create loopholes that will actually open up the opportunities for companies to even not be obliged to comply, but still remain companies that are actually doing big business with the state. And the other part of it...
yes, continue.
Okay. The other part for me, in terms of the state emphasizing more on a transformation of white business and very little on the development of a black business, right, indicates weakness in terms of their thinking. That if you keep on saying, no, I'll only give you tenders if you employ black people in senior position, and you as a state, you don't expect those black people who are presumably will do well employed by white business, but cannot do well starting businesses and tendering directly with the state, which then achieves the objective of empowerment and transformation much quicker than try to always focus on trying to transform a white business.
I think you and our thinking was aligned there, because I was actually going to the issue of the powers that will be enjoyed by the Labour Minister as per this amendment bill. Will it lead to that transformation? As some criticism is that it will increase the amount of red tape and slow down the pace of doing business.
Absolutely, I think their intention is to accelerate transformation. But when you look at some of the compromises that they're trying to make, in particular when they say they want to reduce regulatory burden from small businesses, and then they define those small businesses employing less than 49 people, and then they don't have a turnover limitation on those businesses. At the end of the day, whenever you come up with laws or regulation, people will always find a way around those regulations. One is that companies can limit the number of employees to 49 if they can, or companies can actually break themselves down into pieces of 49 employees, right? Or they can take a big tender from the state with a company that has 49 employees and then outsource to themselves in another company that doesn't have to comply, because the companies that doesn't have to comply will not be the one tendering to the state, but the one tendering to the state will then outsource to the other company. So there's too many loopholes that the compromise has actually created. In fact, it could actually render the whole intervention counterproductive in as far as transformation is concerned.
But let's look at the good aspects of this. I want to see what the positives are, not only for the labor force, but for companies, especially in terms of aligning equity targets for economic sectors and geographical regions according to the new laws.
The targets, I don't know how you arrive at the targets for different sectors that are different, right? It remains to be seen. Do you have different targets for mining and manufacturing and financial services, and based on what, right? I'm not so sure how they're going to do that. It remains to be seen. But having targets, it would actually demystify the whole issue of employment equity and be specific about these targets, because currently targets are generated by companies, which means that you can set as low target as you want, and as long as you're meeting those targets, you're fine. Or some companies set targets and they never meet them. There's no consequences for not meeting those targets. So when the targets are set by a minister, it almost maybe becomes an offense not to achieve those targets, and the minister might be able to take a much more drastic action dependent on a different sectors. And I don't know, maybe the whole thing of sectors will give the minister specific focus in different areas that the minister may feel are not making as much progress as some of the sectors that would have made a good progress.
But can companies, for instance, use these targets? And I know even Busa has raised the issue of how the measurement came about, but can it help improve the employee value proposition for companies to retain the best talent, to recruit the best talent?
Oh yes, I think the opportunity exists there for companies and for employees to find some common ground around whatever proposal that the minister brings. Because at the end of the day, whatever promulgation the minister makes, we will still have to go into the employment equity committees of the various companies with the stakeholders that are participating in those committees. So hopefully one hopes that there may be some progress that is made, or some new impetus that is put into employment equity, which maybe companies could use these new targets as they could provide new energy to the implementation of employment equity, and also empower the workers who are participating in these committees, who sometimes are expected to agree targets, but may not necessarily be sufficiently skilled and empowered to decide targets. And when the minister has given out a target, it gives them something to work with, to engage their employers with. So that part may actually have a positive impact on the entire employment equity program as it exists in the country today.
Really appreciate your time and sharing your insights. Khandani Msibi is the Executive Chairman of 360 GSG, and he's also Group CEO of the NUMSA Investment Company.